Hello, welcome everybody. I'm Ben Powell, the Director of the Free Market Institute. Welcome to tonight's event. It is our last one of the semester. We will be resuming the series, as always, in the spring semester, and we'll have the announcements of the dates and topics of that coming out soon. Although I will tell you that the keynote one will be on March 27th, and it's most likely going to be more midday lunchtime type event for us. And this is on the 5-year anniversary of the 15 days to flatten the curve. And we'll be having Jay Bhattacharya and Martin Kulorf here, who are two of the three authors of the Great Barrington Declaration, talking about lessons learned from COVID 5 years later. But more on that for what's coming next semester, soon thereafter. For now, it's my honor and pleasure to be able to introduce Professor Todd Zywicki. He is the George Mason University Foundation Professor of Law at the Antonin Scalia School of Law at George Mason. He's a research fellow of the Law and Economics Center there, a senior fellow of the F.A. Hyatt Program for Advanced Study in Philosophy, Politics, and Economics, also at GMU, and he's the former executive director of that Law and Economics Center. In 2020-2021, he served as the chair of the Consumer Financial Protection Bureau Task Force on the federal consumer financial law. He received his JD from the University of Virginia, his master's degree in economics from Clemson University, and his bachelor's degree from Dartmouth College. He is the author of more than 130 articles in leading law reviews and economics journals. He's testified several times before Congress on issues of consumer bankruptcy law and consumer credit, and is a frequent commentator on legal issues in the print and broadcast media, including the Wall Street Journal, the New York Times, the Washington Post, Sports Illustrated, Fox and Friends, Fox Business, CNN, CNBC, BBC, the Laura Ingraham Show, and a whole bunch of other places. Perhaps his least illustrious accomplishment is that a little over 20 years ago, he served on my dissertation committee when I was graduating from George Mason University. Todd, welcome back to Texas Tech.
Thanks, Dan. It's great to be here. Now I need to figure out an excuse how I can come back in March to see Jay and Martin. That'll be a great program. So what I'm going to talk about today is the rule of law, and I'm going to try to make sure I leave time for questions. But what I'm going to really talk about is sort of where the rule of law comes from, and sort of the necessary conditions for the rule of law, and understanding why it's so important. And if time permits, I'm going to, at the end, keep a few remarks on sort of threats to the rule of law that I see out in the world these days. So I'm going to very quickly just describe what I think of as the rule of law, and then move into a discussion more about where it comes from and sort of understanding the intellectual roots of the rule of law. Because one of the things that emerges is the concept of the rule of law is really a distinctive Western idea. It arises in the Western world. It's now we've kind of exported it to other parts of the world with varying degrees of success. But there were unique institutional and intellectual influences in the Western world that led to the rise of the rule of law in this part of the world, at least initially. So what can we think of as the rule of law? And there's been a lot of discussion of this through time. So I'm going to give a very summary overview just to give you a sense of what I'm talking about, which is Hayek in The Road to Serfdom gives a pretty good starting point for thinking about what the rule of law is. The way we can think about it is the first thing is that rules are announced beforehand and applied equally to all people, regardless of their circumstances. So you treat the rich and the poor the same. They have the same rules applicable to them, which is of course different from, say, a feudal society or something like that. The second idea is that the rule of law is something that enables you to predict how others are going to behave. And so you can think of the rule of law as basically being subjecting people's behavior to the governance of rules, just as there are sort of rules of a game that sort of describe how people are going to act, or rules of nature, right? Predictable rules, that sort of thing. And so the idea is that it is often thought of as a constraint on the government, but it is also a constraint on other private actors that allow you to predict how they're going to act. And why is that valuable? Hayek says that it's valuable because knowing how other people are going to act and how the government is going to act allows you to make plans for the future. If the rules are constantly changing, you can't plan for the future. And so you can see pretty quickly why the rule of law is generally correlated with things like economic prosperity, freedom, and the like. Noel Reynolds, a philosopher, summarized the rule of law even more succinctly. He said, the rule of law is a solution to a problem. And that problem is tyranny. That problem is tyranny, which is the ability of the government to act in an arbitrary fashion towards people, to pick winners and losers arbitrarily, and to favor some over others with no rhyme or reason. So I think, Hayek's analogy is that you can think of the rule of law as being like traffic laws. Traffic laws tell you if I want to go from A to B, traffic laws tell me what I need to do to get there. Without coming into conflict with other people. We both drive on the right. We all stop at red lights. Traffic laws do not tell you what exit to get off at, though. Traffic laws allow you to pick your own destination and then to get there with a minimum amount of conflict and a maximum amount of cooperation with other people. And so we can think then of the rule of law then as being something that that allows people to predict their behavior, make plans, and the like. And so what are the elements of the rule of law then? In a legal sense, we can identify a couple basic elements. The first, and I think most important, is what we can call constitutionalism. I don't mean literally having a constitutionalism, but constitutionalism is the idea that there are procedural and substantive limitations on government authority. Procedural and substantive limitations on government authority, which says what? But the government derives its authority, its legitimate authority, from following the rules, but those also constrain the government. It both empowers and constrains. That's what a constitution does. And so we see things like, as in essence, being due process, equal protection, these sorts of things that prevent arbitrary actions by people. The second idea is rules-based decision-making. Antonin Scalia, who my law school is named after, once wrote a speech that said that described the rule of law as the law of rules. Now, why do rules matter? Rules are set at a very high level of abstraction, and they treat all similarly situated people the same, as opposed to discretion by political leaders, where they can choose to treat one person differently from another person on whatever criteria that they decide that they want to choose. A second value of the rule of law that Scalia stresses is rules are kind of like tripwires. If the government has a lot of discretion, if the government can kind of set the criteria by which they act, and it's very vague, it's hard to tell when the government has gone too far. But if you have a law like Congress shall pass no law abridging the freedom of speech, right? That makes it a lot easier to know when the government is infringing on free speech rights, as opposed to something that's much more vague. And so rules make it more clear when the government is abusing its powers and going over the line. The third idea is an idea that comes from Herbert Wechsler, and is also very similar to ideas from James Buchanan, the economist, which is neutral principles, or what is called the generality principle. And neutral principles is something we value very much in law, and the idea here is that similarly situated cases, similarly situated situations should be treated equally, and there should be a coherence to how things fit together, which is that it's very similar to rules-based decision-making, but the idea is as you derive factual consequences from general rules, it requires you to have concepts that hold the law together and are coherent with each other, right? And so we can come back to this if you want to in your questions, but I just kind of wanted to give a background to how we can think about the rule of law. And so let's now turn to what I think is the more interesting questions or more relevant questions, which is Where does the rule of law come from? And what are the institutional framework for the rule of law to be able to prosper? So there's a let's first talk about so there's two elements that are necessary for the rule of law to prosper. First, you have to have this idea of a concept of law that arises from outside the state and constrain the state. As I said, that's the concept of constitutionalism, is that there is law that stands above the government, that both empowers the government and constrains the government. The second thing is, and so that's a concept that has to arise. The second thing is you have to have institutions that will actually bring the rule of law into existence on the ground and be able to enforce it. So let's start with the first idea, the concept of the rule of law, the concept of constitutionalism, that there are restraints on the government. And what I think is interesting is you can see three different sources that this comes from in the Western world. The first idea is the idea of natural law. And this is the idea that the government derives its authority, and the government is also constrained in its authority by some congruence with a higher law or natural law. It starts off as natural law, as Cicero, for example, talked about it, but it really takes its form in the concept of natural rights as articulated by John Locke in England. And in particular, we see this influence in the United States where? In the Declaration of Independence. So Locke's argument was there's a state of nature, and in the state of nature we have natural liberty, including the ability to protect life, liberty, and property, and the ability to protect ourselves. When we enter into government, it's prudential, it's pragmatic. We enter into government and we form a social contract because we think our life, liberty, and property will be more secure once we set up a government. Once we are no longer a judge in our own interest and that sort of thing, we set up judges, we set up a system of regularized dispute resolution to regularize this process. But throughout, Locke emphasizes the point that the purpose of the government is to protect life, liberty, and property. Because he says, if you set up a government that then becomes tyrannical, you're worse off than if you were still in the state of nature. Because at least in the state of nature, you can defend yourself. Once you enter into government, you surrender your right to defend yourself. So you would never set up a government that you would empower to tyrannize you. So by necessity, tyranny is defined as is inconsistent with the rule of law and constitutionalism. And so the revolutionaries, the American revolutionaries, looked to concepts like Locke in justifying the American Revolution. And so we see that influence in Jefferson when he talks about the Declaration of Independence and the right to life, liberty, and the pursuit of happiness instead of property, but it's the same basic idea. And what do they do in the Declaration of Independence? Most of the Declaration of Independence is a long list of grievances against the king, right? For specific things that the king has done that have been arbitrary and illegitimate and exceed their power. And they derive from Locke the idea, when you petition your leaders and your leaders are consistently unwilling to respond to your grievances, that's when you have the right to revolution. That underlying the idea of a legitimate government is the idea at some point you're allowed to revolt against your government, and those in the Declaration of Independence said, we've reached that point. We've reached the breaking point where this whole train of abuses entitle us to revolt. So the first idea is natural law. Second idea is social contract theory, which is very related to natural law. But social contract theory is the idea that we come together as autonomous individuals and we reach an agreement on what the legitimate scope of government is, both procedurally and substantively. And that we make that by conscious decision. And so we see this most obviously in the Constitution. If you think of the Constitution itself as a social contract, where they define how the government's going to act, what is the legitimate powers of the federal government, what are the relationship between the federal and state government, It's set up in a way both to empower and constrain the government, and that the government derives its power from that document. It is a constitution that is the source of our governmental powers, obviously. And what's interesting about this is if you look at Marbury versus Madison, the most famous case in legal history in the United States, because it establishes the power of judicial review, the authority of courts to declare laws unconstitutional. Where does that come from? John Marshall says there that that power comes from, you take the law that's in question, the statute, you lay it down next to the Constitution. If the two don't conflict, that's fine. But if they're in conflict, the Constitution trumps the statute, and the statute is by definition unconstitutional and unenforceable. That's social contract theory at work. Whenever the Supreme Court now is looking at the constitutionality of law, the first derivation of that power goes back to the notion of the social contract and the idea that, that the government derives its legitimate powers from the Constitution, and when it exceeds it, it is illegitimate. The third place that this comes from, that I think is most intriguing to me, is history or tradition, or we could call it sort of conservative constitutional, conservative rule of law. And the idea here is twofold. First, the idea here is, and this is relatively unique to the Anglo-American world. Why? Because this is the idea that the power of the government, the rule of law, comes from the English common law. And the idea here is that the government's authority stretches way back into history. And you look at that history as it was set up, 1,000 years ago in England, but argued at least by the Norman Conquest, somewhere in the idea of there. And the long history of the common law is what both gives authority to the government and also constrains the government, or what they call the English Constitution as embodied in the common law. And so in the case, Dr. Bonham's case, the case that establishes this concept of judicial review, Judge Sir Edward Cook says, essentially, this act of Parliament is unconstitutional. It was essentially a Monopolies Act. It's unconstitutional based on the English common law, that the English common law is the source of legitimacy. The one I think is most interesting on this kind of takes it from the common law to a more abstract level. And I've been really studying this one recently because I'm writing an article on it. But Sir Edmund Burke in his speech on conciliation with the colonies really lays out how we can think about this sort of traditional or conservative approach to the Constitution. Now, most people are most familiar with Burke's critique of the French Revolution, right? And Burke's prescient observation that the French Revolution was going to turn out the way it did, essentially, with tyranny, and eventually it would descend into chaos, and they'd end up with a tyrant like Napoleon. And he said basically the reason was they were making too abrupt of a transition from the history of France. What most people are not aware of was Burke had a very different attitude towards the American Revolution. That Burke, in his speech on conciliation with the colonies, says to the British Parliament, if we're talking here, that basically they thought the colonies were getting too uppity, that we were dumping tea in the harbor, and doing all those things we know about, basically rejecting British authority, and in particular they were fighting over an important point, a key point, which is, as Burke mentions, the history of liberty in England was fought over taxation. He says the history of France, liberty in France was fought over, aristocratic privilege, that the history somewhere else is different. His idea is every country is different in the way in which their traditions evolve, their history evolve, and the issues that become the fighting point. So he says, in so many words, we've created our own monster. For centuries, Parliament has been fighting with the king over the taxation power, and we asserted the idea that taxation without representation, which is what the king wanted to do to us, is illegitimate. So don't be surprised when the colonists turn around and say the same thing to us, that they want to tax us without representation. But what Burke does is he says you have to look at the way in which institutions and the concept of freedom and constitutional arise in any particular society to understand the flavor of how this is going to take on. So Burke identifies 6 concepts that he says they can distinguish, if I think of it as he distinguish why he essentially said we should recognize the grievances of the Americans, number 1, or more practically he said we have no alternative but to recognize the rights of American colonists because of these particular historical consequences. So the first one he says is America was settled by Englishmen, that they are predominantly Englishmen. And he said, not only were settled by Englishmen, America was settled in the beginning of the 17th century when the fierce spirit of liberty was strongest in England. He says, by the time we get later on, English liberty's gotten a little less fierce, but these are people who immigrated to the United States, I guess beginning of the 18th century, immigrated when the English fierce spirit of liberty was strongest. And he also says, the colonists are devoted to liberty according to English idea and English principles. Abstract liberty, like other abstractions, is not to be found. And this is the idea that that's this long enumeration of grievances in the Declaration of Independence, right? It's not an appeal to abstract principle. It's an appeal to the way in which the English rulers were violating the established rights and well-defined rights established by the common law and English principle. He also says there's one other important thing that's important about being settled by Englishmen. He says, the worst people to rule over Englishmen are other Englishmen. We're really bad at telling English people how to behave because that's just not in our nature, right? So the first thing he says is, these are Englishmen, they're settled by Englishmen, they have the fierce spirit of liberty in them, and it's not an abstract liberty, it's a concrete liberty. The second thing he looks at is the nature of how the United States was settled. In the West, we have the frontier individualism. Right? We have people going out there, basically settling the continent with no help from the crown and no need for help from the crown. They're basically doing it on their own. They basically just see the English government as a nuisance. They're going out there, carving out societies in the frontier, and become self-reliant. In New England and in the colonies, what we see is a rise of popular government. So, to this day, right, you've heard about the English town meetings and that sort of thing. Essentially what happened was they couldn't wait for England to solve their problems. England was 3,000 miles away over the ocean. So as they set up their own popular government, they got used to solving their own problems with their own popular governments. And for us to come in now and try to impose our will on them isn't going to work very well. They're basically, we don't need you guys. We're solving our problems here just fine and setting up our own governments, right? So the second thing is popular government and frontier individualism. The third thing he points to is the unique religious heritage, which is in the North. You know, it's the North was founded by who? Protestant dissenters, like the Puritans. He said, these are people who were so fiercely protective of their religious liberty, they were willing to get on a boat and sail 3,000 miles to a new country so they could set up their own church and have their own religious liberty. And he goes on and says, not only is Protestantism a dissenting religion from Catholicism, he says, these guys are the Protestants of the Protestants. They're the dissenters from the dissenters because they think the dissenters are not solid enough, right? Not based enough, you might say, right? So he says in New England, what you had were the Protestant dissenters who are ornery, And they just don't take lightly to any infringement on their liberty, starting with their religious liberty, but more generally, they're just the kind of people who are very, very fiercely protective of their natural liberty. He then turns to the South, and this is quite an interesting observation. He says, the South is different. He says the South is settled by Church of England people, which you might think might make them more docile. But he makes a fascinating observation. He says, human nature in the history of the world has taught us that free men who live next to slaves are the ones who are the most protective of their liberties. People who live next to slaves are the ones who are most aggravated, the most fiercest in resisting the idea that they could be treated as slaves. And so he says, essentially, I do not approve, right? He was an abolitionist, I guess. He said, I do not approve of this institution. I'm just observing human nature. And human nature is such that in the South, the fact that they live next to enslaved people makes those who are not slaves that much more fiercely protective of their liberty. So he says in the North, it's the Protestants of the Protestants. In the South, it's slavery that does it. The fifth factor, he says, is simply distance. 3,000 miles of ocean. The ability for us here in England to issue orders that will control what these guys are doing takes weeks or months to get there. There's no way to deal quickly enough with what's going on the ground there for us to actually be able to impose our will on them. And elsewhere he talks about, even if we could impose our will on them, the only way you can impose our will on them would basically be to crush their spirit. And he's like, why? It's like America, the reason we want America is because they have this great spirit, this entrepreneurial spirit. And so, this individualistic spirit that is creating all this wealth and all these exports to the English colonies. The only way we're going to be able to crush their spirit for political liberty is if we crush the spirit that's created all of the economic liberty. He's got this wonderful passage that just makes me laugh every time he reads it. He's talking about the maritime adventures and how Americans will take their ships out to parts of the ocean that nobody in Europe would ever go. Even as intrepid as the English are, the Dutch, he said, these guys go all over the world searching for fish and that sort of thing. And he says that the Americans are still in the gristle of life. Still in the gristle of life. They're just so unfinished, right? And hasn't hardened into solid bone. And that's that spirit, that entrepreneurial spirit that he has. But he says, you just can't deal with people like that from a distance of 3,000 miles overseas. And his sixth one, the final one, is my favorite. He says, the other problem with the Americans is their system of education. And in particular, he says, America is a country of lawyers, which obviously warms the cockles of my heart, right? He says, and the thing with lawyers, he's like, everybody in America reads law. Everybody, other than the Bible, Blackstone's Commentaries on the Law were the best-selling book in the English colonies. They sold as many copies as Blackstone's Commentaries on the Law in America as they did in England. And it wasn't just lawyers who subscribed to it. It was everybody. I was, a little while back, I was in Alabama, and I was in the chambers of the Chief Justice of Alabama, a fascinating man named Tom Parker. And it turns out one of his hobbies is collecting first editions of Blackstone's Commentaries on the Law. And I was familiar with Burke's argument, and he pulls one of these off the shelf, and he was showing me that in the front, on the front page, that it was a subscription to a printing of Blackstone. And so essentially what they said is if 250 people agree to buy this, that'll enable us to print it. And you looked at it and it was fascinating. They had not only the person who bought it, but their occupation. And it was like bricklayer, merchant, lawyer, banker, right? fishermen, right? It was like these people who, just everybody, only a handful of whom were lawyers who actually subscribed to this. He said everybody read the law, everybody thought about the law, he says, and here's the thing with lawyers. He says most people wait until they are actually sort of aggrieved, until something happens to them to complain. He says, lawyers anticipate the evil and adjudge the principle. Anticipate the evil and adjudge the principle. They see the principle that's being violated in the smallest incursion of their rights. So England's view was, look, we just helped you, in the French and Indian War, and we just want to impose some taxes to get our money back. And they were like, so what are you complaining about? And the Americans were saying, what? We're complaining about the principle. You may have a just case, but that does not mean you are allowed to tax us without representation. If we allow this tax, then that means any tax potentially could be allowed, right? They anticipate the evil and judge the principle, right? And so when you think about this third view of the common law and tradition being both the source and the limits on government, you can see how this is reflected in the Constitution. A lot of the Constitution, the Bill of Rights, are not an appeal to Locke's ideas of abstract liberty, but instead it's things like due process, equal protection, no unreasonable search and seizure, no excessive bail. Right? These are all very concrete terms that take their meaning from common law, take their sense from history. And you can think of it this way, which is we have a written constitution in America. England does not. Can we really say that we are freer than England has been for the past 250 years as we're coming up on our 250th anniversary? I don't think so, right? And what Burke is appealing to is the idea that the idea of the rule of law, the idea of the Constitution, the idea of individual liberty are as much about the spirit of liberty and the understanding of us, sort of what is allowed, what is legitimate, as it might be about the formal rules that we have, right? But all three of these are ideas that kind of emerge in the Western world. In the rest of the world, generally what you see, historically, is that the state, the emperor, the emperor is God, or the state has the authority over everybody, and that there's no authority above whatever the state is. All three of these things come together in the Western world to restrain them. So that leads us then to the final things I want to talk about, which is, okay, we've got the idea. The idea is that it comes from somewhere, that the government is bound by rules that rest above it and from which it derives its authority and limits its authority. So then the question becomes, well, how is that actually operationalized in practice? And we can think in here, we can think about two basically characteristics of the Western world, which is why this arises in the Western world. The first is the separation of church and state in the Western world. And this is very important. And there's a great legal historian named Harold Berman who has written very much about this. In most of the tradition of the world, the religious authorities and the government authorities are aligned. So Burke, for example, talks about historically the Catholic Church has always, in most countries historically, the Catholic Church was aligned with the ruling princes, right, in the light, basically going back to the Roman Empire. You can see that today in Russia, for example, right? The day, like today, where, and I'm no Russian expert, so I might be getting this wrong, but my observation is that the Orthodox Church basically legitimates Putin, and Putin legitimates the Orthodox Church. You may have seen since Putin has come to power, the Orthodox Church has become much stronger in Russia. And partly it's because the Orthodox Church supports what Putin is doing, and vice versa. That historically was common throughout most of the world. The Western world was unique, though. Because we had this transnational, international Catholic Church, and you could go all the way back to the beginning, render unto Caesar what is Caesar, render unto God what is God, right? And this developed over time into two separate powerful forces that would check each other. That you would have the state and you would have the church. And as Berman says, that fact that you had these two different forces that could check each other were the vehicle for freedom to emerge and to impose limits on both of them. So he said, if the king was oppressing you, you could run to the church for protection. If the church was protecting you, you could run to the king for protection. And so it was through the clash of these forces that that freedom emerged in the interstices. So what does this look like? This looks just like our separation of powers under the Constitution. The executive, legislative, and judicial branches, all of which check each other, checks and balances and the like. And so since that time, the idea of separation of powers, that one body makes the law, one enforces it, and one interprets it, has been seen as an essential aspect of the need to, of the institutional requirements to maintain the rule of law. And the idea is that, that it's not because any of these powerful people want to give rights to the people that it happens. It's because they can check each other, and by checking each other, they allow ordinary people to have rights. A good example of this is in the Magna Carta, 1215 in England. The Magna Carta, which is seen as sort of the original charter of liberties in the Anglo-American world. What happened with the Magna Carta was the barons imposed the Magna Carta on the king and basically told the king, listen, here's the rules. You want to oppress our serfs, but we're the ones who get to oppress our serfs, not you. But what happened was, through that power of them fighting, what happened next? It turns out that the barons fighting against the king, the next thing that happened was both of them started trying to appeal to the emerging middle class and mercantile class for support, because that's where all the money was. And so what happens? In the second edition of the Magna Carta, when it's reissued after the Pope basically gave authority to breach the first one, when the Magna Carta was reissued and reimposed on the king, what happened? They added a new clause. The new clause provided specific protection for the City of London. For the City of London to be self-governing. That's where all the merchants were. Why? Because even though the barons didn't like it, the barons were basically appealing, to the merchant class to join them against the king. And in order to do that, they basically had to give them a guarantee of their rights. And we see this in the United States, right, in the separation of powers. So you can think about this clash between the king and the church as sort of a prototype of the separation of powers we have today. The second reason why this emerges in Western Europe is because of the unique political arrangement of the Western world. And this can be attributed to Rosenberg and Brazil, two economic historians, who talk about the fragmented political authority of the Western world. We had a lot of very small principalities all throughout Germany, France, and the like. And they were constantly at war with each other. And so they're constantly at war with each other. They constantly needed money in order to get armies so that they could defend themselves and that sort of thing. Well, again, where was the money? The money was in the merchants. And so what would happen is they'd want merchants to come and settle in their communities. But the problem was, the way the princes liked to do it was, oh, I need money, I'm going to just take your stuff. Right? They would just confiscate the stuff from people. But pretty soon, the merchants wisened up to this. And so if they thought a prince was going to take their stuff, they could just load up their wagons, go across the bridge to the prince next door, and all of a sudden now they're on his side. And he's the one who gets to have them. So the ability to be able to exit and move to jurisdictions that would protect your property rights and allow economic development to happen puts a constraint on the ability of princes to act arbitrarily towards their subjects. And what happens over time then is this gets established into a system of regularized taxation, protection of property rights. Why? Because you want the merchant to move from having a wagon to having a storefront, to building a factory. You're only going to build a factory somewhere if you know that the king's not going to come and confiscate your factory. And so that gives an incentive for kings and princes who are in constant war with each other to create a framework where people want to invest and allow and make money that then through regularized taxation they can tax. What does that look like? Federalism, right? So what we see in the Western world is separation of powers and how essential that becomes then to create the maintenance to be able to impose the rule of law on the government. And then at the same time we have a system of federalism which allows people to move among different jurisdictions to those that are more friendly and more protective of property rights and the like. And so in societies where you don't really have first the concept that there's a law that stands above the king, but then even if they have that, you have to have the institutional things in place, like separation of powers and federalism, that will force the ruling authorities to be able to abide by those laws. And so what we see then is in the Western world, the rule of law emerges and becomes vibrant in the Western world. Now, let me turn to the darker part, the less happy part of the story, which is concerns I have about the future of the rule of law. The first is the administrative state, and the way in which the administrative acts towards Americans, or has, at least in recent years. The arbitrary power of the administrative state, and the way in which it acts without the rule of law. Now, I talked about this today at the law school. I won't bore you with a long discussion. The lawyers in the audience might groove on this. But what's interesting about this is Albert Venn Dicey, who first brought the idea of the rule of law into existence in the late 20th century in England, his particular concern was the administrative state. The way in which today the administrative state acts in arbitrary fashions, they don't even act by rules. They act by blog posts and things like that. How many people here are familiar with the internet, the social media censorship cases? That were, where the White House was basically bullying social media companies, imposing pressure on them to censor speech, right? That's how the administrative state works. They've got so much discretionary power that they can essentially impose their will through these informal type means. Well, just give you an example. Before Elon Musk bought Twitter, nobody was investigating him. Since Elon Musk bought Twitter, I think there's 9 agencies investigating him now. Maybe he just started doing bad stuff after he bought Twitter. But maybe that just is an illustration of how the administrative state can drag you through the mud, basically, right? So getting control over the administrative state, I think, is one of the big things for the rule of law. The second thing we see is crises. That the government expands in the arbitrary and discretionary power the government expands during crises. And we've had 3 of these in the past 20 years, which have been very threatening to the rule of law. First, we had the 9/11 crisis, the national security crisis. Then we had the financial crisis in 2008, where the government took the precedents that they established during the 9/11 crisis and applied them in the financial context. And third, we had the COVID crisis, where they took those 2 crises and the power the government got during those crises and ratcheted it up even more, right? Each of these became a precedent for each. And what we learned from these is once the government seizes discretionary power, you can't put the genie back in the bottle. They get it and they don't want to give it back. Politicians don't want to give it back, and there are always interest groups and powerful interests that benefit from that expansion of discretion, because they have the ability through rent-seeking and special interest activity to be able to benefit from this system. So, for example, who ended up being the biggest winners from the financial crisis? The biggest banks. That after the financial crisis, we passed the Dodd-Frank financial reform legislation, supposed to get rid of one thing: too big to fail banks and get rid of bailouts. Does anybody in this room think we've gotten rid of bailouts for big banks forever? No. Nobody thought we did, and just last year we bailed out a bunch of banks that were going under, right? The big banks are the ones that have benefited most from the complex regulatory scheme. Big banks have gotten bigger, small banks have disappeared. A third thing is attacks on institutional legitimacy. And I'll just give an example, which is the attack on the idea that the entire a few years ago, obviously there's problems always with a criminal justice system, but the idea that the entire system is completely illegitimate and completely riven through with institutional racism, right, systemic racism, and that the entire criminal justice system is completely illegitimate, right, that's going too far, right? That sort of attack on institutional legitimacy. One that's really bothered me in recent years is the attack on the Supreme Court, if you follow this. The attack, all with an idea of trying to pack the Supreme Court, right? But these sort of made-up scandals and that sort of thing, in my view, in order to delegitimize the Supreme Court, I think is very, very worrisome. The fourth idea is woke law. I'll just call it woke law generally. And this is a direct attack on the rule of law. That the idea of equal application of the law to everybody is in itself unjust. And I have a whole separate lecture I could give on that. I could say a few more words later about that if you want. But I'm going to close with the last one with this audience, which is what has concerned me the most is elite institutions. And this is a call to everybody in this room, because everybody in this room does have a privilege. We have the privilege that we are people who have been able to go to college, and we are the future leaders of this society. And the ones who really are the elite institutions, universities, media, groups like that. I'm going to focus my scorn here on the universities, which is take the Supreme Court. We just had a candidate who ran for president and was defeated, who one of the platforms was, I'm going to pack the Supreme Court. I don't like the current composition of the Supreme Court. I'm going to pack the Supreme Court. I thought that issue was resolved during the New Deal. We don't pack the Supreme Court in this country. Now, here's what I think is interesting about that. No ordinary American would have come up with the idea that it's okay to pack the Supreme Court when you don't like it. That was an idea that was conjured up by law professors and embraced by other professors, by elite media and people like that, and pushed on the American people that it's okay to pack the Supreme Court. The ideas of the entire attack on the criminal justice system, that came from this. The idea that the entire Constitution is illegitimate. Ordinary Americans didn't come up with that. Elite institutions. And I've learned, one of the things that's been interesting to me recently is I never appreciated the wisdom in the Federalist Papers and the founders. We know, we've talked about separation of powers and checks and balances. We've talked about federalism and the checks and balances. But they also made an interesting point. They said there's also a checking power between populist and elitist. And you can see it in Congress. The House is the populist House. The Senate was designed to be an elitist House. Senators were originally elected indirectly through state legislatures. And the idea is we don't give too much power to the populists because they can be overturned, they can act rashly, and we don't give too much power for the elites because the elites can then basically rule for themselves, like the aristocrats of England. So we're going to have them check each other. The populists provide the passion, the elites are the long-term guardians of the institutions. And this is why I get so furious, which is today, it's the elites, it's the universities that are, and the professors who are at the front of the pack with the pitchforks and torches tearing down American institutions. And I think it's really important for us to appreciate that, and it's important for us to appreciate how important it is as the people who are leaders of the country to talk about the rule of law and stick up for the integrity of the rule of law. And so I'm going to close with a quote from Michael Oakeshott. The rule of law bakes no bread, it is unable to distribute loaves or fishes, it has none, and it cannot protect itself against external assault, but it remains the most civilized and least burdensome conception of a state yet to be devised. And with that, I'm happy to take questions. Thanks.